Well, it's the end of the pro football season, and Tennessee basketball is going strong, and I'm just wondering if there's a mandatory rule these days that everything has to go into overtime. Anyway, it's Kent Jones with Jones & Associates, PC, Cleveland, Tennessee, servicing Bradley County, Hamilton County, Marion County, McMinn County, Polk County, and we go outside those areas on occasion. I wanted to talk to you about part 3 in the series of workers' compensation law for employers in the state of Tennessee. Today I was going to talk about disability. Generally speaking, there are 4 main areas of disability under the workers' compensation coverage. There's temporary partial disability, temporary total disability, permanent disability, and permanent total disability. Temporary partial disability, I think I've covered a little bit, but essentially it is the average weekly wage of a worker, which we've talked about. You take that, and if they're back at work but not making that wage because of their medical condition that relates to the injury, then the employer may be responsible for 66 2/3% of the difference to be paid out on a biweekly basis. Temporary total disability is more common. What temporary total disability is the doctor gives the employee medical restrictions. They come to you, the employer, and present you with the restrictions. You don't have a job whatsoever that they can do, so they can't work for you. So you'll be required to pay what's known as temporary total disability, TTD, and that is 66 2/3% of their average weekly wage paid out on a biweekly basis. Now, most employers, particularly the larger ones, have light duty programs. Some smaller and medium-sized employers either do or can have them. A light duty program essentially puts the injured worker back to work at the same wages and at a job that fits within their medical restrictions. And if you can do that, then there should not be any issue with you having to pay temporary total disability. And temporary total disability runs until the injured worker recovers from their injury to the point to where they can go back to work full-time at a job with the same wages. The next type of disability is permanent disability, and this comes up towards the end of the case. It's when the employee reaches a point which is known as maximum medical improvement. Maximum medical improvement is defined by the physician, but essentially and generically it's a point at which the employee is not suspected to get any worse or any better due to the injury by accident at work. There may be some further things that are done, physical therapy and things like that, but usually doctors will assign an MMI date and at that point give them what's known as a permanent impairment rating. And an impairment rating is based on usually the AMA Guides, which is a book that both lawyers and physicians use. Physicians use it to assign a percentage of impairment to the injury that they have, and they get their maximum rating, and then you're either looking at settling the case or trying it and obtaining a verdict, which all, of course, is internal within the Bureau of Workers' Compensation now and not in the court system. The multipliers used to range from 1 to 5 and then go to 6 if, depending on the circumstances. Now they've been defined by statute in Tennessee Code Annotated 50-6-207. As I understand it, they differ from around 1.35 to 1.45 if the employee lacks a high school diploma or GED, 1.2 if the employee was more than 40 years of age at the time of the period that compensation ends, 1.3 if the current unemployment rate in the Tennessee county where everything occurs is less than the general unemployment rate by a particular percentage. I believe it's 2 percentage points, and then again there can be variations on those multipliers, and that's where you really need to talk to your attorney, because that's where it becomes a little more complicated, because you're using a multiplier and multiplying it by the percentage of disability to come up with a figure that you attach to wages and obtain a final permanent disability amount. Just as an aside, the employee does have a right to go his or own to their own physician if they're not happy with the medical impairment rating. They have to pay for the physician. They may get additional care. They may get another impairment rating, and all these things are things for the Bureau of Workers' Compensation to consider. So that's permanent disability. If you settle and you close out medicals by paying them a sum of money, you can close your books generally and the case is over. Unless it goes further up, which is possible as I understand these days still. The next area of disability is one that you do need to be really concerned about as an employer, and the employee needs to be concerned about it as well. It's entitled permanent total disability, and permanent total disability is a situation where it is determined by everyone that the injured worker cannot return to any job and be able to work with their medical restrictions. And so at that point, then wages are paid out bi-weekly at 66 2/3% of their average weekly wage until the employee reaches the age at which the employee can draw old age Social Security benefits. Well, there are different rules if an employee is over 60 years old, and if you call me, I can discuss those with you. But you can understand that if you got an employee that is in their 20s and they have that type of significant injury, well, obviously it's very bad for the employee, and it's very, very expensive for you, because we're looking at years and years of payments to that employee, and you cannot close your books until all of that's over. If you have any questions about the multipliers, about doctor's impairment rating, maximum medical improvement benefits, anything that we discussed today, feel free to give us a call, 423-424-6208. Email is joneslaw08@gmail.com. Web address, www.jonesandassociateslawfirm.com. Thanks a lot, and hope you have a great weekend.